Hello everybody, and thank you for joining us this morning. Today we're aiming to provide an overview of the legal framework behind retention of title clauses, and then there will be some insight regarding how claims might play out when the purchaser becomes insolvent. I'm James Hopkirk, the Director of Restructuring and Insolvency at Kreston Reeves, and I'll be explaining a little about the process that an insolvency practitioner will go through if there are retention of title claims received from suppliers. I'll then be sharing a couple of practical examples of situations that I've come across. Before that, we'll be hearing a legal overview from my co-presenter, Stuart Mullins, who is a corporate and commercial partner at Clarkslegal, who are, of course, hosting today. Thanks again for inviting me to join you, Stuart. Stuart will be thinking about this largely from a supplier's perspective and provide some tips to ensure that an ROT clause is actually enforceable when there is a default in payment. This will be the third time that we're teaming up for a webinar, and I'm pleased to say that our viewing figures are increasing as we go. Hopefully our slightly different perspectives will continue to allow us to provide a broad overview of the subject area and provide some insight which will be helpful whether you're a business owner, supplier, lawyer, or however else you might be involved in the process. We've allocated time at the end for questions and answers, and we ask that if there is anything that someone wants to raise or any questions you'd like to ask, please note that down using the chat function. We'll collate those as we go and then address them all at the end. We'll be sharing the slides and recording of this webinar with attendees following the webinar. And finally, I just mentioned that it would be helpful if everybody could ensure the videos and mics remain off whilst the presenters are speaking. Hope that's all clear. So without taking up too much time here, I'll pass over to Stuart. Thanks.
Thank you very much. Thank you very much, James. And hello, everybody. I hope you're all well and I hope you're all safe. And thank you for joining us today. I think before we move on to probably the more interesting part of the webinar, James's overview of the impact on retention of title clauses and practical considerations in the context of insolvency, I think we have to sort of set the scene really, and we have to just understand a little bit more about what they are, the sort of types of clauses that come together to form an appropriately protective RAT clause and explore some of the law around it. And I'm sorry if it gets a bit dry. I will try and keep it brief, but as I say, we are going to have to explore some legal concepts really to understand the issues that can come out around these clauses. So firstly, retention of title clauses in and of themselves, the concept is pretty simple really. What we're talking about here is retaining title and possession ultimately over goods by a seller until that buyer has paid for them. And they are enforceable generally. They've been in and around English contract law for some time, and they're pretty important in certainly the manufacturing sector. So what's the issue? What's the issue with them? Well, we're going to pull together through my presentation some of the issues that have been played out in the courts as to why they have been challenged, or on what grounds they've been challenged, and what grounds they've been held enforceable, and what grounds that they haven't. And a lot of the cases in and around the enforceability of these clauses really do fall on the facts of specific cases, and the devil really is in the detail of the drafting. So I hope at the end of this you'll have a flavour of the sorts of things that you need to consider when putting them into your agreements. Well, what is clear is that it's important to secure the legal and beneficial title of the goods that will be the subject of a retention of title clause. Well, that sounds very legal, doesn't it? What's the difference between legal and beneficial title? Well, beneficial ownership of something is generally regarded as your ability to enjoy the goods, as opposed to legal title is, your ability to be recognised as the owner of goods. So perhaps one of the easiest ways to understand the two concepts is if you think about a pension, for example. You've got the person who pays the pension contribution. Well, they're beneficially entitled to that pot because they've paid the money. But the legal title to the cash or the funds or the investment are ultimately owned by trustees. So you can see the difference. So when we think about drafting ROTs, we do need to ensure that in that drafting we specifically refer to the concept of ownership and title when putting our pens to paper. And the next point to understand is this concept of bare trust or an equitable charge or charge. And again, a lot of the cases that have been looked at by the courts have identified in certain circumstances an absolute need to identify what's called a fiduciary relationship when looking at an ability to claim over proceeds of sale. And what do we mean by a fiduciary relationship? Well, generally, it's one in the context of perhaps agency, which is essential in order for a seller to have a charge over shares, over the share of sale proceeds. Conversely, if a charge is identified, if the courts, having analysed the clause, don't understand or don't come to the conclusion that the necessary ingredients are there, what they'll do is they'll determine that effectively that the seller has a form of charge against the company, and that charge in and of itself generally should be registered against the company concerned. And because it hasn't been registered, it's void or indeed unenforceable against third parties. But I'll come on and talk about that in a little bit more detail. So we understand, therefore, that it's essential to include beneficial and legal title, and we need to ensure that certainly when we're dealing with proceeds of sale, that we establish a form of fiduciary relationship, such as an agency relationship or an obligation to have the monies kept in a separate account to give a seller a right to enforce. But what we also have to do is we have to think about some of the other provisions that we need to include to practically prohibit or restrict any buyer from being able to distribute or sell on those goods without the protection. So there's a classic list of things that we should always include: rights to prevent goods from being sold on or used until payments are made. So rights to take back goods in certain situations. No doubt James will mention this in a little bit more detail, but the Corporate Insolvency and Governance Act 2020 has curtailed those provisions in certain circumstances, and an obligation upon the buyer to keep goods separate and identifiable and not mixed with any other goods to ensure the readily identifiable nature of those goods until payment has been made. And we'll come on and talk about that in a little bit more detail when we look at some of the typical clauses that go into making up the retention of title provisions. You have to think a bit broader than just the mechanics of the clause. You have to think about how you're going to incorporate those clauses and how they sit in the contractual relationship of seller and buyer. So it's imperative to have regard to provisions regarding payment, risk, and title and delivery, and when they all pass. So, you know, if in the battle of forms, the process of ordering, offering, accepting, orders are made, accepted, invoices raised, paid, purchase orders, you do need to understand within all of those that context that title passes on payment of goods and not simply on delivery if you are going to rely on a retention of title clause. And then you also have to think about, well, okay, well, we accept that legal title shouldn't pass until we've been paid for the goods, but what about risk? Do we want risk to pass on delivery rather than payment? Because if you're a seller, you don't necessarily control those goods when they're paid over. So thinking about the mechanics of these clauses and how they operate in the context of the wider contract and some of the other provisions that can overlap, I think is very, very, very important. I think we just have to look at some of the sort of classic clauses that go into to make up the retention of title provisions, really. And I think there's some points to make with regards to all of them. An all monies clause has huge benefits, really, because if you're a seller supplying multiple deliverables to a buyer, many invoices, perhaps under an umbrella agreement with purchase orders, having this ability to control goods until all of those goods have been paid for is very useful without having to identify each individual component of an invoice or indeed purchase order. The downside with the all monies charge is that a court could construe this against as a charge in effect over the assets, and therefore the point I made earlier about the need to register that charge to ensure that it's binding against third parties and insolvency practitioners is an issue, but I'll say no more about insolvency. Interestingly, the House of Lords, in hearing an appeal on a Scottish law case, didn't believe that an all monies charge on the facts of that particular case did constitute a charge. It's interesting because what's persuasive on the English courts, it's not necessarily binding. And I think here's the point of caution, that when we're putting these particular clauses together, it's also always important to ensure that they can be severed from the body of the agreement. What do we mean by that? Well, we want to draft them in a way that if a court does decide on a particular provision or clause of a provision of a contract, that they are able to strike that through without affecting the other provisions of the agreement, because if they can't so sever, then the whole mechanic will be deemed to have been stricken through by the court. Proceeds of sale clauses, again, you know, this ability to control proceeds of sale. As I say, we discussed this. I've mentioned this earlier. It's really important to establish this fiduciary duty between seller and buyer to give any form of enforceability. It really does come down to cases involving the relationship of seller and buyer, where they are often the buyer's often acting as the seller's agent. The issue, of course, here in establishing this sort of fiduciary relationship often means that the seller is responsible to the end buyer for defects in those goods rather than passing them on to the buyer and the buyer simply reselling. So there could be a number of reasons why the relationship with seller and agent isn't appropriate. But as I say, I think that's a necessary ingredient for proceeds of sale clauses to be upheld, and that was certainly the view of the courts in the leading case in this area, and the reason that sometimes these clauses are called remolpa clauses after that case. And certainly in manufacturing, that the next point is to ensure that we deal appropriately where goods are to be mixed with others, mixed goods clauses. Where goods retain their identity, or such as maintaining their original form, or can be easily removed from being annexed to another particular good, it's clear that the identity will result in a retention of title clause being upheld. Where that identity is eroded because it's being mixed in or amalgamated with other goods to create a product, then there is new title in that product, and it's very clear that that title will vest in the buyer. I just think it's worth considering, again, in the wider context, the mechanics of the contract, and we do need to ensure that buyers' attentions are drawn to these clauses. We do need to ensure that mechanics are in place between the parties, such as, deposit accounts for proceeds before paid over are in place, and those processes are there. And with any contractual provision, be it limitation as well as retention of title, for example, we do, as I say, need to be very clear as to when the contract's formed and which sets of terms and conditions will prevail, and to ensure there's clear consistency there. I think it's also important to ensure that the contract and operations of the parties are consistent with the mechanics of that contract, and therefore that contract should be reviewed and the practicalities of the relationship monitored to ensure that they are so mirrored. I think you have to have regard to trading behaviours and customs as well. There has been cases, for example, involving an obligation to provide finished goods for immediate resale. Didn't sit or wasn't consistent with the terms of an all monies protection, and the validity of that was successfully challenged. I think it's important also to consider the effectiveness of these clauses when you have goods which are of general low value or perhaps perishable. There's no point against the time, cost and expense of putting in place a wonderful retention of title provision in your agreement if by the time you come to enforce it the goods have effectively been destroyed or perished and carry little residual resale value. And I think what's key here in this area is to ensure that, as a protection for payment, because that's what we're talking about here, it's reducing the risk and exposure of the seller against non-payment under a contract. You have to consider all the other areas that can come to play there. Strong credit control procedures, for example, monitoring credit worthiness, for example, references, for example. All of these things will enable you to risk assess your buyer, which really forms part of your overall protection. And then the other area, which, as I say, I'm sorry that this was probably dry, for consideration, and I'll say no more, but hand you over to James, is the impact of these clauses where your buyer becomes insolvent. So thank you for listening, and I'll hand you over to James.
Thank you, Stuart. Successfully reappeared. And can I have my first slide, please? Okay, so the first thing to say is that ROT clauses are very prevalent, and so in many insolvent situations, I'll be dealing with people who want to assert a right to recover goods that they've supplied. There is, of course, a very basic logic to it. The supplier provided goods on the basis that they would be paid for those goods. They're now told they're not going to get payment, so why can't they just have them back? As an insolvency practitioner, I'll very often find myself explaining the need to balance the position of one particular creditor against the position of the general body of creditors. So my duty is to obtain the best outcome for the general body of creditors, and that's not every individual creditor separately. So fortunately, there's a legal framework that Stuart's been talking about to refer to, and as liquidator or administrator, I have to ensure that any goods that are passed back to one particular creditor are definitely subject to an enforceable retention of title clause. Otherwise, it's just eroding the assets of the company for no good reason, which will prejudice every other creditor. So how do we do that, ensure they've got a valid clause? So I'll answer the question, first of all, from a perspective of a business being closed and a liquidator is trying to sell the stock, okay? So the comparison will be to an administration, which I'll look at in a minute. Anyway, from the liquidation perspective, the liquidator isn't able to sell stock which is subject to ROT, so it's a good idea to get on with agreeing the claims as quickly as possible. The first thing we do when we're notified of a claim is to issue a questionnaire asking the supplier to set out the circumstances of the supply and provide documentation. We want to know, is there a clause and what type is it? So in order to be incorporated and enforceable, the ROT clause must have been agreed by both parties prior to the supply. So ideally, we'd see some terms and conditions which have been signed by both parties at the outset of their trading agreement. And from that, we'll know whether we're dealing with the most common clause, the simple ROT clause, or the more complex all monies clause, which again, Stuart covered in his part of the talk. So if we don't have signed terms and conditions, which happens more than you'd think, suppliers will often argue that the ROT wording is written on their invoice, but unfortunately for the supplier, this is a grey area at best. The invoice will be sent after the supply, typically, so any wording on there won't add to the agreed contractual terms of the sale. There might have been a long trading relationship, and the supplier may be able to argue that the purchaser was aware of the intention to include the ROT clause, having seen many previous invoices, although that leads on to the question of who has seen the invoice. You know, do they just go to the accounts function, or are they approved by a genuine decision maker at the purchaser? So, you know, that's about whether it's properly incorporated into the terms and conditions, but, you know, what are the impacts of the different clauses? So a simple clause is your basic retention of title clause that states that title to specific goods is retained by the supplier until payment has been received in full. That's, you know, as Stuart set out, that's the simplest clause. And the most common. So if the clause is shown to be validly incorporated, then the supplier will be given the opportunity to attend site and identify goods which they have supplied. So ideally, this process will be done by reference to some sort of stock numbering system, and the purchaser will be expected to match the two items on particular unpaid invoices. We can have various issues at this stage. For instance, you know, where a purchaser buys goods from more than one company and then mixes them, which, you know, Stuart covered and suggested safeguards against that. So clauses can be built into the terms which would be helpful for the supplier. So on the other hand, a valid all monies clause seeks to allow for retention of title over all goods until all monies due from the debtor are paid to the supplier. So this clause might appear separately in the terms and conditions to bolster a simple clause. If we have this type of clause, rather than starting by looking at the particular goods, the insolvency practitioner will need to look at the prior trading relationship and see when the last time the supplier's account was paid down to nil, which, you know, for an ongoing trading relationship, that might have been many months or years ago. Any goods provided after that would then fall under the retention of title clause, and the supplier would still need to show that the goods were supplied by them, but the process of identification of specific goods might be less onerous. Suppliers should recognise that usually a purchaser has a right to sell goods which have been purchased subject to an ROT clause, and therefore it may be that not all of the supplied goods remain at the site. Again, Stuart covered off how suppliers might be able to bolster their terms and conditions, but as I understand it, the default position is if the terms and conditions are silent, then, you know, the purchaser does have a right to sell, which for me makes sense in the context of, you know, a trading business paying on 30-day terms and, you know, selling to keep his cash flow going. So if the supplier suffers a shortfall because some of the goods have been sold, then they will most likely just have an unsecured claim in the liquidation and rank for a dividend with all the other creditors. I note that Stuart mentioned as well clauses which purport to cover proceeds of sale covered, proceeds of sale of goods covered by ROT. So in my mind, certainly from an insolvency perspective, a supplier would need to show me that they've registered a charge before I considered that. And in reality, suppliers don't tend to register charges. So that kind of wording in the terms and conditions may not be enforceable. But again, we can get legal advice on those sort of things if needed. And next slide, please, Stuart. Oh, come on. So in the liquidation scenario explained on that slide, if the ROT creditor has a valid claim, then it's generally accepted that they have the right to recover the goods. However, when a company files for administration or files a formal notice in court that they intend to appoint administrators, a moratorium automatically arises, which creates a protection around the company guarding against a broad range of creditor enforcement action. This includes action in relation to ROT, and a supplier won't be able to repossess goods unless he has the sanction of the court or the administrator. So the purpose of the moratorium, generally speaking, is to enable the business to be preserved as much as possible so as to retain value for the general body of creditors. Looking specifically at the period prior to administration, I've seen situations where suppliers start to get wind of the fact that a company is preparing for an insolvent sale. Maybe they've run out of patience, they're not being paid. You know, there might be rumours going around the industry, or one of the insolvent company's staff might have said something. If you are preparing for a pre-packed sale, then, you know, from my perspective, having a queue of suppliers seeking to have their stock returned can be very problematic. So even if the administrator has a legal right to retain the stock, which you will have. So I should make a quick point that if an administrator retains the stock and sells it, he'll need to ensure that the supplier is paid for those goods. If the supplier has a valid ROT clause, you know, the administrator can't just retain the stock and ignore the ROT issue completely. So in my experience, if suppliers feel like they're going to lose out, especially if they feel like they've been misled about the financial state of the company, which they may well have been, they're not going to be too interested in the intricacies of the insolvency legislation. And I've seen suppliers try to exert pressure in different ways with a view to getting their stock back. So as well as causing general disruption at the trading site, where staff are already feeling vulnerable and stressed, you know, suppliers sometimes suggest they'll spread the news that the insolvent company is facing difficulties, maybe to other suppliers or even to the press, depending on the profile of the company. As well as preserving the value of the actual assets, an insolvency practitioner must be concerned also about the value of goodwill, and any damage at this stage may impact how much a prospective purchaser is looking to pay for the business. And again, ultimately my job is to maximise recoveries for creditors, so that's a pressing concern. It's therefore the case that deals might be done with particular ROT creditors prior to the appointment if the insolvency practitioner thinks that the benefit of retaining particular items will be outweighed by any damage which might be done to the business. For example, a creditor might be owed £10,000, but there might only be £250 of his stock at the site. You know, they might supply something perishable, some kind of food. In that situation, unless the items were crucial and couldn't be obtained elsewhere, it would probably be the easiest thing to review the ROT claim very quickly and assist the creditor in reclaiming what he could, validly. So when drafting terms and conditions, suppliers of goods should be mindful that the default position is that a purchaser will have an implied permission to sell, as I said above. You might think that where directors are aware that a company is insolvent, then they should cease operations to preserve the position for each creditor. But that can, however, be in conflict with their duty to preserve the value in the business as a whole by, the way to do that is to continue to trade. So the situation with each ROT claim, in conclusion, is not clear. If a supplier becomes aware that the company is facing insolvency, they may wish to take legal advice to establish what steps can be taken to prevent the insolvent company dealing with the unpaid goods any longer. But again, I'll come to it a bit later on the final slide, there are practical steps that they can take as well. Next slide, please, Stuart. Okay, so now we'll look at the situation where an administrator is appointed and he wants to sell the business on day one as a pre-packed sale. We did a very good webinar on pre-packs last time. So I'm sure the recording's still floating around on that one if you're interested. The administrator may have a situation where the company has 100 or more suppliers, and the administrator is unlikely to have had the time to review each supplier's terms and conditions and review the stock levels for each supplier. So if the business is to be sold as a going concern, then it is necessary to find a way to transfer all of the stock, but to safeguard the position of those suppliers with valid retention of title clauses. The first step that the sale agreement should note is that the administrator is selling only such right, title and interest as the seller may have in the goods. This avoids inadvertently transferring ownership of goods which were effectively still owned by a supplier who hadn't been paid. That's bordering on sort of criminal offence conversions, things like that, which the administrator wants to avoid. But the administrator could still face criticism for surrendering control of the goods unless safeguards are put in place to protect the position of the ROT creditors. So if goods subject to a valid ROT claim is sold, then the administrator will need to account to the supplier from the proceeds. The sale agreement should formalise a process which, depending on the complexity of the situation, may cover the following areas. The administrator, a legal obligation anyway, regardless of what the sale agreement says, is that the administrator has to notify the creditors of the sale of the business. That should be done ASAP after completion, and the administrator will invite ROT claims to be submitted. So the idea being that the creditors have a fair opportunity to raise concerns, sort out their issues. So upon completion, the buyer and the administrator can agree on the accuracy of a detailed stock list, which will be referred back to. That obviously depends if such a detailed stock list is available. But the point of selling the business, again, as a going concern, is that the purchaser can begin trading immediately, and they may therefore sell goods before a claim from a supplier is received, and it's therefore very helpful to have a point of reference for the stock position at the point of completion. so that the credits can be accounted to. The duties of the administrator upon receipt of a claim will also be covered, so they may need to issue a questionnaire to the supplier to obtain full information regarding the claim, and they'll also need to notify the buyer within a certain period of time, which again, given the ongoing trading, you'd think would be a very short period of time. So the buyer's duties upon receiving a notification will also be set out. These will be centred around cooperating with the administrator. So they probably need to set aside stock until the claim is resolved. They'll need to allow the creditor to come and inspect the goods, and then if there's a valid claim, they'll need to allow the creditor to come and collect the goods. So, you can put whatever you want in a sale agreement. So, you know, it might be that you want to provide for periodic update meetings with the buyer as the administrator, just so you can ensure that these protocols are being complied with. So ultimately, the administrator will need to retain responsibility of agreeing whether the supplier has a valid claim or not. The buyer will obviously have an interest in retaining as much stock as possible, especially if they've acquired stock at a fixed amount, which factors in their risk of losing some because of ROT claims. So there will be a reliance on cooperation from the buyer, which, and you know, the buyer might be connected to the insolvent company, it might be the same director. It's therefore important for the IP to demonstrate that safeguards are in place, just so that creditors can have confidence in the situation. We had a situation where the ROT claims were going to have a real material impact on the purchaser moving forward from a pre-pack, and although the directors wouldn't provide a guarantee for the deferred consideration, we insisted that they provide a guarantee in respect of the performance of the ROT provisions, so that if a creditor lost out because the purchaser circumvented the agreed protocol in some way, then we'd have been able to take action against the directors personally. And again, that's important to me as an insolvency practitioner, because creditors, you know, need to know that we're taking seriously the potential for things going missing or, you know, loss to be suffered. So I should mention that an administrator is effectively an officer of the court, or they are an officer of the court, and they'll have a duty to act impartially in these matters. The sale agreement should set conditions to allow the administrator and the purchaser to quickly establish whether any supplier has a valid ROT claim, and if so, for that creditor either to be compensated or for the goods to be returned. I, as an administrator, won't want to be getting into any negotiations at that stage. You know, for me, it becomes black and white. You've got a valid claim, you have the stuff back. You haven't got a valid claim, you can't have it back. So the purchaser, however, and the supplier may reach agreements which are more informal, especially if they don't have an ongoing trading relationship moving forward. You know, for example, the purchaser might say to the supplier, okay, I acknowledge you've got a valid claim. We haven't got the money to pay you in full now, but let's pay you over 3 months if that's okay, that sort of idea. So next slide, please, Stuart. Okay, so on to some sort of examples of where this has arisen. And as Stuart covered, the basic rule is that if goods are incorporated into something else, then an ROT claim is going to fail. That's, you know, basic rule. Although there have been various cases and precedents, and that has been refined a little bit. So we need to consider whether an incorporated item can be removed in its original form. So I learned that lesson when I was dealing with the administration of an engineering company, and it wasn't the sale of the business, but we were selling goods from site, and the company had this nice valuable piece of engineering equipment. I think our valuer said it was worth about £80,000, which we were including in our usual sales process. It was going to auction, but we got a letter from a creditor saying, hang on a minute, we supplied a component that's been fitted into the machine, and you know, there's £13,000 outstanding. what are you going to do about that? So they wanted to remove it, and our agents basically said if it gets removed, then the £80,000 piece of kit isn't going to be worth much because it's not going to work. So we originally said, sorry, it's incorporated. There's no ROT there, I'm afraid. But the supplier had clearly been through the situation numerous times, and they came out with their complex legal advice plus practical advice about how they could remove it without damaging anything. And in that position, we had to weigh up the cost of defending the position, which when you're talking about £13,000 piece of kit, if the legal fees start running into the thousands, then immediately you're thinking, is this worthwhile? So, ultimately we ended up doing a deal with them and said, let's not spend lots of money arguing about it. We'll sell the part as it is. And I think we settled it, maybe giving them £10,000 out of the proceeds towards their £13,000 debt. Another one that's always fun, we had a logistics company, another administration, and they owned a fleet of vehicles that we wanted to sell. Tyres were on all of the vehicles, but some of them hadn't been paid for. And again, there's a more sort of pressing argument, I think, there, that the tyres have been incorporated and processed. Obviously, they're damaged in the running of the vehicles. So you've got a fairly strong legal argument that the tyre companies aren't allowed to come and recover those goods. But unfortunately, the tyre companies tend to have different ideas. And in that case, we weren't able to properly secure and safeguard the vehicles inside. And there was a risk of, these tyre companies coming along to repossess or, cause damage to the vehicles. So in that situation, we looked at the cost of setting up the creditor compared to the damage it would do to the value of the vehicles, and it just made sense all round to pay them and let us sell the vehicles without the threat of finding them lifted up on bricks or whatever. The last example I'll mention, we had a food distributor. Again, this was an administration, but we were building up to a Prepacked, well-known business with very well-known restaurant customers, that were on every high street. So it was a fast-moving, accelerated sales strategy. The business was teetering on the brink of falling apart because some of its customers were going, the staff were very concerned, and ROT creditors started to arrive, threatened disruption. We're going to tell the other suppliers, tell your customers, and there was a real risk of deteriorating value of the business. So, this is one particular guy was on site talking to the employees. I had to go down to talk to him and tell him he had no right to remove the goods, but he was effectively saying, I don't care, I'm not going anywhere. So, in that situation, what do you do? The director wanted us to phone the police, and if you found the policeman who had an in-depth knowledge of insolvency law, then he may well have helped us remove this guy from the site. But from the supplier's point of view and from the police's point of view, the story is effectively that this guy hasn't been paid for his goods, and we're telling them that he can't have them back. So I've seen before firsthand that the police are just keen to avoid any sort of altercation, and their view would be, seems fair that he should have it back. So in that one, we quickly weighed up what stock was actually there. I think we let the guy remove maybe £1,000 worth of his stock that was still there. A lot of it had already been sold, but that kept him happy. But we then quickly arranged our security to secure the site so that no other people could get into the premises. I mean, that was where the practicalities of a situation overtake the legal side of things. So hopefully that's a little insight into what can happen with ROT clauses. The lesson that I'm sure Stuart would like you to take away is to ensure that your clauses are properly drafted, properly incorporated. And that really is the moral of my story as well, because if you're having an argument with an administrator or a liquidator, you want to know that you're in the right, so that you can put the pressure on them to get your stock back to you or get payment to you. So I'll now pass back to Stuart, who can field some questions.
Thank you very much. Thank you very much, James. That's very useful. I think we can really sum up, therefore, that when considering retention of title, the first thing is to consider what's customary practice in your particular trade or sector. I think you then have to think about your business in the wider context of what other processes and procedures you can put in place to safeguard and ensure adequate DD, due diligence, is carried out on your buyer, credit monitoring, regular credit checking, all of those things. I think you have to consider really whether or not it's proceeds of sale that you're looking to protect, and if so, are you going to try and create that fiduciary relationship of separate deposit account, and are you going to monitor the performance to ensure that the contract is being carried out in a way that reflects reflects the position, or should you be considering taking some form of debenture or other charge over your buyer, given the nature of your business and the relationship? We have to ensure that the clauses we put in place can be severed if there's a successful attack on their enforceability. And then we also have to ensure that we're very clear in all people within your business who are directly impacted or directly relate to the contractual process, understand that these provisions are adequately incorporated into relations. So thank you, James. Just coming to some questions. One for you, James. Why would an administrator take the risk of transferring stock subject to retention of title? Why wouldn't they just give it back? Well, James, would you like to answer that?
Yeah, that's fine. I mean, again, I've touched on it briefly in my slides, but the primary duty of an administrator is to obtain the best price for the assets. And we'd love to do all the due diligence in the world to ensure that everything that we transfer has been paid for, but the main concern is time. If we're doing an accelerated sale process, there's just not going to be sufficient information readily available or time to establish the correct position for each creditor prior to a sale. I mean, you just need to listen to your presentation there, Stuart, to sort of appreciate how complex it can get for each individual supplier. It's normally going to be the supplier's terms and conditions, not the company's or the insolvent company's standard terms and conditions. They're all going to be different. And the alternative for an administrator is to only sell what is 100% paid for. But a business might not be operational on that basis, if you're only going to sell half the stock. So, it's going to have a real material impact on the value. So, with a good protocol in place, the risk of creditors losing out should be minimal, unless the purchaser circumvents the provisions, and that will in turn minimise the administrator's potential exposure. So that's how we do it, and how we can sleep at night doing it.
Okay. Thank you, James. We've got two questions here. Is there a best practice to ensure ROT clauses are incorporated into contracts? And another one is it sufficient to include such a clause in terms and conditions and invoice? I think I'll just pull together one answer on that. I mean, when as a contract law, one of the things I always say is that to any business owner is that, you know, you do have to bring some considered thought to how your business transacts. You do have to be able to set out on a flow diagram or be able to illustrate all the points at which you will sell your goods or indeed services, but we'll focus on goods today. Because once you are clear in your mind as to what points you are going to contract and how you're going to enter into those relations, the skill of a lawyer is to build around the protections to ensure that those terms and conditions and that contractual relationship with your buyer reflects the very practice that you are operating from. It's no good taking template documentation and thinking that's the end of the process. Incorporation of terms and conditions and battle of forms, you know, is the subject of many books and theses in their own right. So I think the point to bear in mind is that once you are clear as to where you could slip up in the contractual process, i.e. where a buyer could present their terms and conditions over and above yours at the point of contract, you just have to be mindful that that yours prevail through that process, and that's often an education tool or training session with your with your sales team. I think that what's clear from case law is that you do have to draw attention to this to a buyer. So you do need to be able to demonstrate that you have gone through a process with the buyer and explained, I think, that there are retention of title provisions and that these are how they operate. I don't think it's sufficient to just stick it on the back of the invoice. I do think, or indeed any terms of business, I think you do need to go through a contractual process where you can evidence the fact that people have read them and hopefully understood them to ensure your protection. And in terms of is there best practice, well, I think it depends on the best practice is to ensure that it reflects the way you trade and do business. That is the best practice. Thank you for those. James, one for you. What happens to any shortfall that's owed to a creditor after recovering their goods? I think what they're asking there is if the retention of title clause doesn't cover the recovery of the goods, doesn't cover the entire debt owed pre-insolvency.
Yeah, so even if a supplier can recover all of their goods, you know, there's no guarantee that they'll be able to recover the full debt, because, you know, if they've been sat on another company's shelf for 3 or 6 months or whatever it is, then you know, they might not have the value that they originally sold them for. So plus in most circumstances, as I sort of alluded to, it's likely some of the goods will have been resold, and therefore, you know, they're going to be looking at getting some of their goods back, which might cover some of their debt. So in that situation, if there is a shortfall, which almost always is, the creditor will rank as unsecured, as an unsecured claim, basically, behind secured creditors, behind some employees, and most HMRC claims, which counts preferential. So they'll just be alongside other suppliers and other creditors. That's about the size of that.
Okay. No, thank you, James. I'm just checking to see if we've any further questions. No, I don't think we have. Well, thank you all for joining us today. I hope you found it useful. As ever, if you think of something or you wish you asked a question today and you know it pops into your head later, you should see James and my details, their phone numbers, email, etc. Please don't hesitate to get into touch. thank you again. James, thank you very much for your input, and I hope you all stay well and keep well, and have plans to enjoy the sunshine that's eventually arrived. Maybe we'll have a summer after all. Thank you very much.
Thank you.